Hi friends, hope you are fine and doing well. I welcome you once again to the lecture series called Law Simplified, initiated by Just Law Academia. Now friends, today we are going to discuss an important topic called appeal under CPC. See, appeal has not been defined under CPC, under the code. It simply means that judicial examinations of the decision by the higher court. The purpose is that to err is human, judges are also human, they may commit mistake while appreciating the evidence or the facts of the case and give the wrong or erroneous decision accidentally. But the cardinal principle of law that act of court should not cause harm to anybody. So keeping in view this principle and note, a person who has been aggrieved by the decision has been provided a remedy to make a request before the higher court to review, to reconsider, to re-examine the decision rendered by the lower court or the trial court. See, the provisions with regard to the appeal has been provided under section 96(2)(112) of CPC and under order 41 to 45. As we discussed in the lecture of decree, that every decree is appealable, herein under section 96, certain rule which we are going to discuss, which you have to keep in mind while understanding the concept of appeal. Section 96 provides that appeal shall lie from every decree of the court of first instance. Now here you need to understand that it is not necessarily that the first appeal would always lie before the district judge. District judge sometimes may act as a court of first instances in certain cases. In that case, the court of first appeal would be the high court and not the district judge. So therefore, the lawmakers have intentionally used this word, the court of first instance. It could be the lower court of a civil judge or it could be the court of a district judge as well. Fine. 96 subsection 2 say that it may be filed against the ex parte decree also. Fine. So if the ex parte decree has been pronounced, has been passed by the court, then appeal against that would be lie again in the higher court. Section 96 subsection 3 further provides that no appeal in case of a consent decree. Now if the decree has been passed on the basis of the compromise or the consent of the party, then the appeal would not lie against such a decree. Section 4 further provides that no appeal except on a question of law from a decree of the nature cognizable by the court of small causes when value of subject matter of the original suit does not exceed rupees 10,000. This was amended in the year 99. If a decision has been rendered by a court of small causes and the subject matter or the value of the suit is not exceeding more than rupees 10,000, then no appeal would lie except if there is a question of law is involved. Now my dear friends, few points which you have to remember. One is that it's not a matter of procedure, it is a substantive right which has been provided by under the statute. Fine. So if it is a creation of a statute, then certain conditions could be imposed. For example, under the High Court rule and order, certain conditions could be imposed, like if you have to file an appeal against the money decree, then 50% of the amount you are supposed to deposit at the time of filing. So it is subjected, it could be subjected to the conditions. And appeal is always considered as a continuation of the original suit rather than as a, you can say, inception of a new action. Fine. So, it is a statutory right which has been provided, conferred, vested with the person who is aggrieved one. Fine. It could be subjected to certain conditions as well, and it is a substantive right, and it is not a matter of procedure only. It is not inherent like in the case of a suit. Fine. If you know the rights are infringed or the wrong happens to you, we can seek damages, we can file immediately a suit. Fine, but it is not in the case of the appeal. Fine. Aggrieved or the adversely affected person has a right to appeal. Fine. So, the right of appeal lies with both the persons who is either aggrieved or adversely affected by the decision. Now, one more thing which you have to remember is that against the ex parte decree, the appellate court would only hear the merit of the case, but will not hear as to why the appellant did not appear on the date of final hearing before the trial court. So, my dear friends, here when the appeal is filed, although he has a separate remedy under order 9 rule 13, we will discuss in another session. Fine. In case ex parte decree is passed, he can, what are the remedies available to him, but in case he has availed the remedy of filing an appeal, then the court has to touch the merit of the case and not heard him on the ground that why he got failed in appearing before the London trial court. Now, consent decree is not appealable. Section 96 subsection 3 clearly specifies so that it is not appealable, but it may be set aside by a separate suit on consent on fraud. I mean, his consent was obtained by fraud or the coercion, like on these grounds that could be challenged by way of separate suit. Right. Now, section 97 further makes it clear that since we discussed kinds of decree as well, preliminary and final. If there is a preliminary decree and somebody was aggrieved against the preliminary decree, but he did not initiate the appeal, now after declaring of the final decree, he cannot challenge the preliminary decree. Fine. So, he is precluded to challenge the grounds of a preliminary decree. Fine. Section 98 say that 2 or more judges hears an appeal which is to be decided in accordance with the opinion of such judges or of the majority of such judges. If no majority which concurs in a judgment varying or reversing the decree, appeal from such decree shall be confirmed, means the appeal would fail in that case. So, section 99 further say no decree to be reversed or modified for error or irregularity not affecting the merits of the jurisdictions. So, merely on the technical grounds, the decree cannot be reversed unless it has resulted the failure of justice. So, my dear friend, this is with regard to the first appeal we have covered from section 96 to 99. For the second appeal and the procedure aspects, say, as you all aware that the code has been divided into section and the orders. Sections provides the general principle and order lays down the procedure, and section 96 to 99 of a first appeal is always to be read with the order 41, which lays down the procedure or the mechanism for the whole thing. Similarly, order 42, that deals with the second appeal, and order 43 deals with the appealable order. Order 44 deals with the appeal to be filed by the pauper, and order 45 deals with the appellate procedure by the procedure adopted in case of appeal by the Supreme Court. Fine. So, my dear friends, in a detailed series of lectures, we will be discussing the whole procedure of the appeal, and we will be dealing with these orders one by one, but I think it is enough for today. So, thank you so much.